Listen-only mode.
Good morning, friends, and warm welcome in this special webinar on merger and acquisition. We are very thankful to you all for joining in the morning. We are very thankful to you, CS Praveen Soni sir, CS Nagendra D. Rao sir, President of the ICI. We are very thankful to you, sir, for accepting our invitation. We are very thankful to our both the speaker, CS Vinit Nagar ji and Advocate C. Nipun Singhvi ji, for making this wonderful webinar. In this post-COVID era, we'll see so many merger and acquisition, and there are so many judgment also we have received in the NCLT in the IBC matters, so which will discuss in our today's webinar. So first of all, before we start, we would like to tell about Connect Easy. We have done so many sessions, around 500 plus sessions in the last 1 year. We are very grateful to that many of our panelists are also have joined today. Even we have Praveen Soni sir is our keynote speaker in the past, so we are very thankful to you. We have done 21 episodes which physically challenge chartered accountant as an inspirational story. And today we have a wonderful presence of CS Nagendra D. Rao sir, a president of ICI. First of all, we'd like to invite CS Praveen Soni sir. So for inviting, would like to request CS Pooja Singhal ma'am to formally introduce CS Praveen Soni sir. As in Mumbai or Western region, sir, is not required any introduction, but as a part of formal introduction, we would like to request Pooja ma'am to introduce Praveen Soni sir.
Good morning, friends. I am here, Pooja Singhal, again on the screen, once for you again. And here today I am going to introduce Mr. Praveen Soni sir. So I am not capable to introduce him actually. He is self-introduced, I know very well. Each and every person from ICAI, ICSI or my fraternity knows him very well, not even from Western region, from the whole of India actually. So, Praveen Soni sir is a member of Institute of Company Secretaries of India and also a law graduate. And he is a Central Council member at present of ICSI, has headed various positions at various committees of ICSI and also having various positions. Last position I remember which I had met him personally was ICSI CCJRT chairman in Navi Mumbai. So, and he is presently serving to CMS Info Systems Limited as a company secretary and head legal over there. So this is a very short and crisp introduction of Mr. Praveen Soni sir. Now may I request to Soni ji to please come on the screen and share his knowledge and wisdom about the topic to the participants. Please, sir.
Thank you, Pooja ji, for this lovely introductions, and thanks Virag ji for giving this opportunity once again. My respected friend and my dear friend into my council and president of the ICSI, CS Nagendra Rao ji, speaker of this program, Nipun Singhvi ji, and Vinit Nagar ji, and the founder of this Connect TV platform, Virag Shah ji, and my own colleague into ICSI, Pooja. Thank you so much once again for giving this opportunity. And I believe this spread of education is an important task or assignment or donation or social service, by whatever name we can say. We can do and we are doing. And this has been absolutely in a wonderful manner being done by the Virag. So Virag, a big round of applause for you, and I would say kudos to you for this taking this assignment, because I remember we earlier I was there in your programs at Dadar, I think 4 years ago, and then we met, and then last year I think you invited me for a program as a technical speaker, and then this Carva is going on. And last couple of months I am watching your program, and I can see big speakers, all the Central Council members and President and ICSI. And on your request, I am thankful to President ICSI again for being there and sparing the time and agreeing to be connect with the Connect Easy. So I think Connect Easy is really a Connect Easy, I can say, to connect the people and professionals in an easiest manner, and to serve to the humanity, to serve to the professionals. One of the wonderful things which I heard from you is that you have served to the, especially for the physically handicapped chartered accountants. May I request you to not to limit this with the chartered accountant and do serve to this for all the professionals whosoever can benefit out of this. Because recently in the ICSI Council, we opened the doors for the people, those who have lost their parents due to this COVID, to have a free registrations in the ICSI curriculum. So thanks to the visionary president of ICSI, Mr. Rao, for this. Apart from this, we try to bring to cover more and more people into this our CSBF criteria and to provide financial assistance to the our members, those who have lost their life due to this COVID pandemic. In fact, even to far more, the assistance was extended to the people, those who are not the member of the CSPF. So that because life is valuable and whatever best institute can do, institute will always do, and we are doing. But the acts done by I would say the pillars of the profession, those who are always carrying it, like I can say Virag, who is nowhere holding any position or as an elected member to the Institute of Chartered Accountants of India or any other body, but yes, they are giving benefiting to the people by their own contacts and own resources. Last week, I think I requested him personally to participate one of the program as an audience because it was a wonderful topic which I feel, and the speaker was Mr. Mantri, and he's elaborated the topic very well. So I think Virag, wonderful job has been done by you. Keep doing this, keep doing this. Thousands of people have already get benefited, and you may not know that later on, after coming period of time, you may have your own institutions like this and wonderful speakers and participants you may have. So thank you so much, Virag, and keep going. Our president is there, other speakers are there. I would love to hear from our president also. Thank you so much, Virag, once again for inviting here and being us here, and keep doing good things. Whatever support you require from our side, we are always there, whether in personally or from the institute side. Thank you so much. All the best.
Thank you so much, sir, for your kind words. Your appreciation really means a lot to us, sir. Thank you so much. So now would like to introduce our today's guest, President of Institute of Chartered Company Secretary of India. Profile would like to read as sir is a fellow member of the ICSI. CS Nagendra D. Rao sir is a law graduate from University of Mumbai and has a bachelor degree in commerce. Sir is a designated partner and founder of CS Nagendra D. Rao and Associate LLP, a form of practicing company secretary in Bengaluru. Sir was elected to the Central Council of the ICSI for the term 2019 to 22 and served as a Vice President of the ICI for the year 2020 before being elected as the President for the year 2021. Sir has more than 15 plus years of experience in corporate sector. Sir is specialized in corporate and securities law, capital market transaction, business planning, merger and acquisition, financial restructuring, strategic investment, funds planning and arrangement. Prior to setting up his whole-time practice, Sir has also worked with multinational companies. Sir has been associated with ICSI for several years now. Was elected to the Southern India Regional Council for 2 terms, that is 11 to 14 and 15 to 18. Has served as a chairman for the year 2015. Prior to that, Sir was elected to the Managing Committee of the Bengaluru chapter of the ICSI for the period 2007 to 10 and was evaluated as a chairman during the year 2009. CS Nagendra D. Rao was a member of the Central Taxes, Corporate Law and GST Committee of the Federation of Karnataka Chamber of Commerce and Industry for the year 2018-19. Sir was a member of the Corporate Affairs and Taxation Committee of the Bangalore Chamber of Industry and Commerce during the period 2000 to 2004. As a recognition for his outstanding service rendered in the field of education, CS Nagendra D. Rao was conferred to the title as Vidya Vikas by Dr. D.G. Shetty Education Society, Dharwad, Karnataka. So with this brief introduction, sir, we welcome you, sir, for today's keynote address, sir. Thank you so much.
Thank you, Virajji. Am I audible?
Yes, sir. Yes.
Okay. Very good morning to all the esteemed members present over here. CS Viraj Shah, founder of the Connect EC. CS Praveen Soni, my dear friend in the council, always bubbly, coming with new ideas, new vision, new thought process. CSI. CS Advocate CA Nipun Singhviji. I have heard him a lot, and I remember in one of the program where I have also interacted in Bangalore. It was a hit, a super hit. Like in South, we say Rajnikant hit. It is the same kind of a stuff when we see him talking on various topics. And he was a celebrity, to be very frank with you. And I was not aware that Nipunji is going to talk on this particular subject. Since I have to go to Delhi today, otherwise I would have really loved to be a part of, at least to hear Nipunji once again. CS Vinit Nagar ji, CS Pooja Singhal ji, a very, very good morning, and to all the esteemed members of all the three professions, where I am seeing all the chartered accountants, company secretaries, advocates, and also all other our cost accountant friends being present over here. At the outset, let me once again wish you a very, very happy good morning Sunday. Probably Sunday people would have got little bit late compared to that of others, but I could see the warmth and the enthusiasm amongst the members, especially those who are present over here, gearing to present themselves before the Connect Easy program. Friends, COVID-19 has, as we normally say, that every coin has two sides. Similarly, COVID-19 is a opportunity as well as the sufferings. So as a professional, one of the most important thing which I find is that for a professional, I find it is more an opportunity compared to that of small sufferings what either we had or our family members had, or our friends, well-wishers, our dear ones, near ones had. Before that, my homages to all those members of our fraternity, all the three fraternity, as well as the advocate friends, who probably because of COVID-19 would have lost their life or their friends or their family members. Homage to me, I'm sure that they may not be physically present, they may not be there with us, but mentally they will always remain with us. Their good wishes, their blessings will always be showering upon all of us to take our professional fraternity, whatever practice we follow, to a newer height, to a newer glory. At the end of the day, we all professionals, whether it is advocate, company secretary, chartered accountant, cost accountant, or any whatever practice, we are serving not only for ourselves, but we are serving for the nation, because because of us, we find that we make the nation. So therefore, as I feel that COVID-19 has given more opportunity compared to that of sufferings. Yes, sufferings are there, no doubt about it, but there are many learnings. One of the most important learning is, like earlier days, or now also we say, and concept of corporate social responsibility. Now we have moved from corporate social responsibility to an individual social responsibility. We now are more individually Atmanirbhar, what we normally call as, that we used to depend upon our others, but you find COVID-19 has taught us that we did not have to depend upon others. We have to depend ourselves, as well as we have to ensure that we take all others amongst us. COVID-19 has also brought all the professionals and all the professional institutes together. Maybe chartered accountant, cost accountant. I have never seen a president of CA, president of CS, president of CMA in one particular platform on not one occasion, on various occasions. So that is what I am saying, that it is an opportunity to learn more and more and more and more. In physical programs, probably it would have been possible only to attend one single program. But today, we would like to hear esteemed speakers like Vinit ji, Nipun ji, who may be addressing in various forums. And you will find that many more members would have got the benefit out of those particular knowledge sharing what takes place. I think that technology innovations have been extremely well brought in by virtue of holding so many webinars. I am very happy to note that Connect Easy, under the founder Virag Shah ji, you have held more than 500 plus programs, as well as kudos to you that you have motivated all other professionals by inviting physically specially abled people, so that we can do it. That is what the concept or the message is. So when a specially abled person can do it, we as a normal person can do that particular thing. So kudos to you for involving them as well and giving an opportunity, spreading a new lease of life, let me put in that way, to all those. There are many students who probably for one or the other reason, I know for sure, there are many of my friends who say that अरे 10th अटेम्प्ट हो गया, 10 अटेम्प्ट हो गया, 5 अटेम्प्ट हो गया, 1 मार्क से निकल गया, 2 मार्क से निकल गया. So that is only inspiring the other students that yes, when our friends can do it, we can certainly do it. I am very happy to note that you have been organizing so many webinars. Please keep all those programs doing, and I'm sure that knowledge spreading is one of the most important thing so far as the Hindu culture is concerned, or our culture is concerned. Knowledge sharing is considered as one of the Vidya Dhanam, is considered as one of the most Shrestha Dhanam, what we call as. So spreading of knowledge, spreading of light, spreading of information to all those members, whichever profession a person chooses. But at the end of the day, we all will be more and more learning from the words of wisdom which will be given by the various notable speakers, what you will be calling upon. I am very much thankful that you have invited me for the inaugural program of this Connect Easy. I'm sorry that on one or two occasions it was not possible for me to join because of there are certain hectic schedules which are there. Of course, I would not like to give any excuses, because giving excuses, I don't think as a professional we should give. But you can understand, being a president of the institute, there are so many things which are happening side by side and answerable to 65,000 members and more than 2.5 lakh students, and many initiatives which are taken by the institute, not necessarily only by president, with a council colleague, positive mindset like CS Praveen Soni, who shoulder to shoulder taking the responsibility in ensuring that yes, we take certain important steps for the benefit of members and students. I'm sure that we all, whether it is CA, CS or CMA, one voice we talk about, and that is more and more knowledge sharing for the benefit of members, for the benefit of students. Whichever profession a particular person may pursue, I'm sure that your programs Connect Easy would help each and every members to hone their skills, update their knowledge, and be relevant so far as the industry is concerned, be relevant so far as their practice is concerned. Very happy to say that from 1st July onwards, NCLT has also opened the doors so far as the regular hearing is concerned. So only those urgent hearings which earlier used to take place, now you will find that all of us would be more busy, would be more engaged with the regular hearing which is going to take place from 1st July 2021. I'm sure that the technical sessions, I do not want to talk more on mergers acquisition, because talking in front of merchants and acquisition in front of Nipun, it would be like to show a what we say, a light to a sunlight. So therefore it may not be appropriate for me. I would only say that I wish all the best for all the members of Connect Easy. Keep learning, hold more and more webinars, because in this midst of pandemic 19, you will find that we always get carried away sometimes by negative thoughts. Holding more and more programs for the benefit of members, students would only engage themselves into coming out of those negative mentalities to a positive mindset and build ourselves. Let us, like say for example in Mahabharata, you would find that Arjuna had to undergo a vanvasa, or the Pandavas had to go on vanvasa. COVID-19 is also like a vanvasa for all of us as a professional. Let us have that armory of all the skills. What Arjuna had got, the Brahmastra, what Arjuna had got, the Divyastra, what Arjuna had got, many astras. Let all our professional friends also get the knowledge of all the astras, so that whenever they appear before the NCLT, whenever they appear before any regulatory authority, we are equipped with all our arrows to give the answers to the various questions which would be put forth by the statutory authorities. With these words, I conclude by congratulating once again to Virakshaji and all those members who are connected with Connect Easy, and I'm sure that you will take not only connecting all other members of the profession irrespective of their practice, but will spread more and more education, more and more knowledge. And knowledge, you will find today, knowledge does not come free, but you are spreading knowledge freely. I am very happy that we can sit at our doorstep and can understand, learn, calling. I know Nikunji stays in Mumbai, I suppose. He had to come down to Bangalore. He had to come down to Chennai for giving his program. Entire whole day it will go. Similarly, you will find sitting at his office or home, he can address so many lectures, spread so many lights, give so many special advices, guidance, tips, whatever it is, and present so that at the end of the day, you will not only win the cases, but also you win the heart of all the members, all the students, and become the torch bearer of a professional. I am very happy that you have invited me. All my best wishes. Any help required from our side is concerned, I'm sure Pravinji is always will be helping you. Any other help is required, we are always there. Thank you. Jai Hind, Vande Mataram.
Viragji, you're on mute.
Thank you so much, sir, for your kind words and appreciation. For us is a lot to us, sir. Thank you once again, sir. Praveen Soni sir is already always connected with us from last so many years during our physical workshop when we have done in 2017. At that time also we have invited all the 3 institute council member. We have a Shruti Shah madam at that time from Institute of Chartered Accountants. We have a Debasis Mitraji from Institute of Cost Accountants of India. Even yesterday, today is the MSME day. So, sir, we always, as a professional, think about our clients. So, yesterday we have a special session for practitioners. We have celebrated SMP Day, International SMP Day for small and medium-sized practitioners. Sir, on 1st July, we are celebrating GST Day, and would like to inform you and all the audience as well, sir. We have got the invitation accepted by Institute of Cost Accountants of India President, sir. So we are Debasis Basu, sir. So we are again holding a few more webinars on these special days as well. We are very thankful to you, sir. Again, you have accepted invitation and addressed all the attendees, sir. Thank you once again. Thank you so much. Thank you, Praveen Soni sir as well, sir, for always supporting us, guiding us, and we are very thankful to you, sir. And now would like to invite our first technical speaker, Advocate C.A. Nipun Singhi Bhai. I think Vinit Bhai is taking first session, so Advocate Vinit Nagar ji, sir is again excellent orator. Sir is from Ahmedabad and practicing in NCLT and IBC matter as well. Sometimes major practice area is NCLT. So would like to request Vinit Nagar Bhai to take the proceeding ahead for our first technical session.
Thank you very much, sir. It's always a pleasure to be a part of such kind of webinars wherein our Chief President is addressing a welcome speech. As far as the topic is concerned, I must say very less time is there to discuss more of the topics, because as far as the discussion is concerned, it is classified into 2 parts. One is going to be a part of compromise and arrangement in context with the IBC, and other thing, all the matters which are pertaining to the compromise and arrangement, wherein the matter of corporate law structs and some prominent judgment which has been passed by the High Court, Supreme Court, and now by NCLAT also. So I would like to go with the judgments which has been passed recently, all the judgments which has been passed in the past, which has been reversed by the NCLAT. So commercial wisdom was one of the part which I could like say that Mihir Mafatlal clearly it states that as far as the commercial wisdom is concerned, the absolute authority is going to be the company's shareholders or the company's creditor, those who have sanctioned the scheme of compromise and arrangement. But recently NCLAT judgment has peeped into the commercial wisdom if it is benefiting to the few shareholders or few creditor who are related to the promoter group. So shareholder which relates to the promoter group and if it is prejudicial to the interest of minority shareholder, then NCLAT has dismissed such application also. I would like to share my screen in order to have a view with regards to all the judgments which has been compiled for the today's session. Virakji, is it visible? Sir, is it visible? I'm trying to share my screen. Is it visible to the participants? Now, as far as the jurisdiction part is concerned, now if both the companies are registered in a separate state under the jurisdiction of two separate ROC under the jurisdiction of two separate NCLT, then in that circumstances, it is required that you should make a separate application to both the NCLT having a jurisdiction over transferor and transferee company. Now, in this context, there is one judgment recently passed by the NCLAT and dismissing the order which was passed by the NCLT Ahmedabad bench in Ambuja Cement. So, as far as the jurisdiction of each petition is concerned, it must say it will lie with the NCLT of the state in which the registered office of the company, wherever the transferor or transferee is situated. And if two companies having their registered office in two separate states, then in that case, NCLT having a jurisdiction in that state. So I must say, as far as the stamp duty is concerned, it is stated in the Bombay High Court order in the case of Chief Controlling Revenue Authority, MSS Reliance Industries Limited, wherein the company involved in the scheme of merger are located in more than one state, then approval of tribunal in both the states is required. Therefore, the stamp duty will also be paid on both the instrument. As far as this stamp duty part is concerned, I must say both the transferor and transferee company has to make the separate payment with regards to stamp duty. Now, in this connection, recently one order is passed in connection with Ambuja Cement. Now, this is the case wherein DIRK India Private Limited and Ambuja Cement Limited. This is the Ahmedabad bench Code 2 matter, wherein the learned NCLT did not allow dispensation of the meeting of the equity shareholder and creditor of the appellant company. This is the stage 1 application, wherein the primary application which we used to made before the NCLT is we used to seek the dispensation with regards to the meeting of the shareholder. We need to see, or we used to seek the dispensation with regards to the meeting of the creditors. Now, in this connection, the transferor company was the wholly owned subsidiary of the transferee company. The transferor company was wholly owned subsidiary of the transferee company, meaning thereby all the shareholders of the transferor company, ultimately those shares are going to be cancelled because the ultimate holder was the transferee company. Now, in that case, the counsel appeared for the appellant. Here, the Ambuja Cement Limited has made an appeal to the NCLAT. And the grounds of appeal was the NCLT Ahmedabad bench did not permit the dispensation with regards to the meeting of the shareholders and meeting of the creditor. Now, the counsel who was appearing on behalf of the Ambuja Cement, they have pointed out this fact that the Ahmedabad NCLT has wrongfully rejected the plea of appellant company for dispensation with regards to the meeting of equity shareholder, secured creditor and unsecured creditor. Now, their say was very much limited that since all the shares of the transferor company is going to be cancelled, it will not dilute the shareholding of the transferee company, and hence none of the shareholder of the transferee company is going to be affected. And in that case, they have sought the dispensation with regards to the calling above the meeting of the shareholder, but NCLT Ahmedabad bench has denied and the matter has been raised to the NCLAT. The learned counsel submitted that the net worth of the appellant company is highly positive and there are no secured creditor in the appellant company. Now they have sought the dispensation with regards to the unsecured creditors also, but the unsecured creditor was large in number, and meaning thereby no dispensation has been achieved, and hence the matter has been reached to the NCLAT, wherein it was stated that the transferor company being a wholly owned subsidiary of the appellant, it need not issue any shares to the shareholder, hence the scheme would not result in any dilution in the shareholding of the appellant company. The another point which has been submitted by this NCLAT, by this Council of the Ambuja Cement is, he said that under the scheme there is no compromise and arrangement with the shareholders or the creditor, and no sacrifice of any amount due to the creditor. Hence, the scheme would not prejudicially affect the creditor or the shareholder of this appellant company. It is also stated that the asset base of the Ambuja Cement was double or more than double of the of its indebtedness, the due payable to the unsecured creditor. Now, considering all this contention, they have also stated that in NCLT Ahmedabad bench, there was a reverse order which was passed in Vodafone Idea Limited, wherein the NCLT Ahmedabad bench has granted a dispensation with regards to the holding of the meeting of the creditors as well as shareholder. But in case of Ambuja Cement, the NCLT Ahmedabad bench has denied such a dispensation. It was there in the Vodafone Idea Limited. It was submitted that the applicant company, now this is the extract of the judgment passed in the Vodafone Idea Limited, wherein the NCLT Ahmedabad bench, the same bench has granted a dispensation, wherein the wordings were, it is submitted that the appellant transferee company is a listed public company, both the transferor companies being a wholly owned subsidiary of the appellant company, no shares are required to be issued or allotted as a consideration for the proposed amalgamation. It is submitted that in the instant case, there is no arrangement by the applicant transferee company with the shareholder, and further the right of the shareholder of the applicant transferee company are not affected as no new shares are being issued to the shareholder. Now, in this case, again, it was a wholly owned subsidiary company which was merging with the Vodafone Idea. In that circumstances, the dispensation was allowed on this ground. It was further stated that the transferor company, the proposed scheme does not involve any reorganization of the share capital. In this circumstances, there is no arrangement with the equity shareholder of the applicant company. The right of the said shareholder are not affected by the present scheme. Therefore, no meeting of the equity shareholder of the applicant transferee company is required to be convened. In view of the fact given, this bench is of that view that there is no requirement to convene or hold the meeting of the equity shareholder of the transferee company, and accordingly, the meeting of the equity shareholder of the applicant transferee company has been dispensed with. Now, this is something wherein the same case, same bench, but the order was not the same when the matter was placed by the Ambuja Cement. But on the contrary, there was one more case wherein it was stated that if it is the case when the transferor company is a wholly owned subsidiary company and a transferee company is owning the 10% share capital of the transferor company, in that circumstances, considering the liquidity of the transferee company, there is no need that transferee company should even present the petition separately. It is provided in Mahamba Investment Limited versus IDI Limited, wherein it is stated that in the present case, having regards to the relevant clause of the proposed scheme, particularly the provision where no new shares are sought to be issued to the member of the transferor company by the transferee company, the scheme will not affect the member of the transferee company. The creditor of the transferee company are not likely to be affected by the scheme in view of the financial position of the transferee company. So it is stated that as far as the shareholder is concerned, no new shares are going to be issued by the transferee company. And as far as the creditors of the transferor company is concerned, considering the financial position of the transferee company, the dispensation was granted. In para 13 and 14 of that order, it was supporting the company's application that the financial position of the transferor and transferee company have been set out, which would show that as far as the transferor company is concerned, it has an excess asset over the liability to the extent of 508 lakh, where in case of transferee company, there is an excess of asset over the liability to the extent of 6,900 lakh. So considering this financial viability of the transferee company, it was decided to grant exemption or waiver with regards to the requirement of calling up of the shareholders meeting and creditors meeting. And the great thing about this particular judgment is the circumstances, the office objection is accordingly disposed of with the clarification that it is not necessary in fact and circumstance of the present case. One more thing which was clarified by this order is In such circumstances, no separate application is required to be made by the transferee company. The Honorable High Court in the above judgment even held that filing of separate petition by transferee company is not necessary. The learned counsel of the appellate relied upon the judgment and submitted that the transferor company had already filed an application. Now, in this circumstances, the transferor company has made an application to the Mumbai bench. I'm talking about this Ambuja matter, wherein they have not got transfer. The Ambuja cement was under the jurisdiction of Ahmedabad NCLT bench, whereas the transferor company was under the jurisdiction of NCLT Mumbai bench. NCLT Mumbai has granted the exemption or dispensation with regards to the calling up of the separate meeting of the shareholders and creditor. But transferee company, where the jurisdiction of NCLT Ahmedabad bench was there, NCLT Ahmedabad bench has not allowed the dispensation, and hence the matter has been moved to the NCLAT. The learned counsel for the appellant relied upon the judgment and submitted that since the transferor company had already filed an application before the Mumbai, and Honorable NCLT Mumbai allowed the application by dispensing with the meeting of the shareholders and creditor, he submitted that as per the above judgment, it is not even necessary to file a separate application by the transferee company, which is 100% holding of its subsidiary. So I must consider this particular fact that if a transferor company, which is a wholly owned subsidiary of the transferee company can seek dispensation as far as the requirement of calling up of separate meeting is concerned. As far as the separate meeting of the shareholders and creditors is concerned, you can get and you can avail the dispensation from the creditors meeting if the asset base of the transferor company as well as transferee company is more than what the liability of the transferor and transferee company collectively is. So this is with regards to the fact that transferee company can seek dispensation with regards to the meeting, and no separate application is required to be made by the transferee company in such circumstances. So this is one of the case wherein a wholly owned subsidiary is merging with a holding company, wherein the matter is before the jurisdiction of NCLT. Now this is falling under section 233 also. They can opt for the fast track merger also, but considering the transferee company being a listed one, wherein it is not possible to procure the consent from those shareholders who are holding 90% of the share capital, and hence they have, rather than opted for the IRD route, they have opted with the NCLT route, and this was the judgment in the circumstances. So I must say that as far as two separate jurisdiction is concerned, in that circumstances, you have to make a separate application to both the NCLT having a jurisdiction of the transferor and transferee company. Now, another thing is with regards to the appointed date and effective date. Now, as far as these two dates are concerned, there are so many judgments, and all the judgments have made itself very much justified that effective date or appointed date is something which is not defined or which is not provided under the Companies Act that what has to be an appointed date. But recently a circular which has been issued by the Ministry of Corporate Affairs in the August 2019 would like to go with the appointed date and effective date. Generally, appointed date is a date from which all the asset and liability of the transferor company will be considered as an asset and liability of the transferee company, but that will be effective from the effective date. Now, as far as the appointed date is concerned, section 232 subsection 6, which states that the scheme under this section shall clearly indicate an appointed date from which it shall be effective, and the scheme shall be deemed to be effective from such a date and not at a date subsequent to the appointed date. We used to specify an appointed date prior to the filing of the petition before the NCLT, but this is just a habit, or this is somewhere a culture we used to follow. But there are certain judgment which clearly states that it is not required to be any calendar date. It can be a contingent date also. We can go with this also. As far as the appointed date and effective date is concerned, now appointed date is a date on which, I said, it is a date on which the asset and liability of the transferor company shall vest and shall stand transferred to the transferee company. Meaning thereby from that day, the transferor company will hold the asset liability as a beneficiary, or I must say as a trustee for the benefit of the beneficiary, that is a transferee company. The accounts on the appointed date form the basis for the valuation of the share. Appointed date is relevant for the purpose of assessment of the income of the transferor and transferee company. and from which date it will be effective. So from the date when the order of the NCLT, the true copy of the order of the NCLT, we used to file it with the ROC, and when ROC approves the same, that is the effective date. Now, as far as the nature of business from the appointed date and effective date is concerned, I have seen many shareholders agreement which used to be created for that period between appointed date and the effective date, so that all the decisions which are being taken by the shareholder of the transferor company, all the decisions which are being taken by the board of directors of the transferor company shall not prejudice to that scheme of merger, shall not prejudice to the interest of the transferee company. Now here it comes. As far as the nature of business, transferor to carry on the business in a good faith and with a prior mutual consultation of the transferee company, and that's why they used to enter into some SHAs also with a reasonable diligence, business prudence, and should not take any business decision without prior mutual consultation of the transferee company. And now transferee companies shareholders are presently having no control over the transferor company, but since when the appointed date has been fixed, they enter into such kind of agreement which is provided there. Companies can execute SHAs which could be effective between appointed date and effective date. Otherwise, the scheme would end up being bulky for the court purpose. The shareholders agreement contain the way and means of taking decisions in ordinary course of business, the list of transactions which require the approval of transferee, and appointment and removal of the KMP and other banking transactions. So for that limited period, see, it will be effective from effective date, but the asset and liability which are standing as on appointed date, that is going to be considered as the asset and liability of transferee company from that appointed date, but it will be effective from the effective date. So in this interganium, I must say the control can be retained by the transferee company by entering into such kind of agreement. Now, in this regard, recently I've gone through one of the judgment which is quite interesting, wherein the appointed date was not pre-decided. Yes. Now this is one of the case wherein there were two companies which are merging into one of the transferee company. Now all these three companies are into finance. That was, as far as this Madras High Court matter is concerned, it was clearly stated that the appointed date need not necessarily be a specific calendar date. So it can be based on some event also. Now, as far as this part is concerned, there are three petitioners who has filed a petition seeking sanction of the scheme of amalgamation placed before this Madras High Court. There were three companies. One is Equitas Microfinance Limited. That was a transferor. Another one was Equitas Housing Finance. That was again a transferor. And this two transferor company was proposed to merge with a transferee company, that was Equitas Finance Limited. Two companies, and I must say all three companies are governed by the Reserve Bank of India, being the nature of their business. So one was the Equitas Microfinance Limited, the other one was the Equitas Housing Finance, and the third one was the Equitas Finance Limited. Now, the scheme which they have proposed, in that scheme, there was no calendar date specified as an appointed date. In circumstances may the case was Equitas Microfinance and Equitas Housing Finance Limited, both were the subsidiary of one company. Both were the subsidiary of one another company. That another company has made an application to the Reserve Bank of India in order to carry on the business as a small finance bank. So these are three companies having no correlationship of the holding and subsidiary. This two transferor company were subsidiary of one holding company, and that holding company has made an application to Reserve Bank. Reserve Bank has given in principle approval, subject to the fulfillment of certain conditions. In principle, approval was received, and the holding company of this, both the transferor company, was about to carry on the business of small finance bank, Equita Microfinance, and this Equitas Housing Finance Limited. Both are subsidiary of one holding company. That holding company has nothing to do with the scheme of merger, but yes, after this merger, these shares will be the shares of that holding company in this Equitas Finance Limited, which is a transferee company. Now, in this case, the scheme analysis is that the merger of the transferor company 1 and 2 with the transferee company. In this context, it is noticed that the first prayer in 3 petition is identical. All 3 companies have made a separate application, and separate application made by transferor and transferee. The prayer were identical, and the prayer were, insofar as the company petition is concerned, since these are the petitions filed by transferor company, quite obviously they have made a prayer with regards to the aspect pertaining to the delayed dissolution. Generally, what we see, effective date will be the date when ROC has approved that Form INC 28, that is pursuant to the filing of order of the NCLT with the ROC, and pursuant to which it leads to dissolution of the transferor company without winding up. But here it was stated that the prayers were with regards to the pertaining to the delayed dissolution without winding up. Now, since the prayer were somewhat typical, and therefore, for the sake of convenience, they are extracted here and there. The prayers were the scheme of amalgamation of Equitas Microfinance and Equitas Housing Finance Limited with Equitas Finance Limited enclosed as Annexure 5 of that petition be sanctioned by Honorable Court with effect from appointed date. With effect from appointed date. But here the appointed date was decided on the basis of when that holding company will be eligible to carry on the business of that small finance bank. It is provided so far as binding on the shareholders and the creditors of the petitioner company. Here it comes. The petitioner company be dissolved without the process of winding up in a manner provided under clause 15 of that scheme, and shall be dissolved on 30th day from effective date. 30th day from the effective date, and not from the date of the sanction of the scheme by the court. Generally, the transferor companies stand dissolved without winding up from the date when this sanction of the tribunal or the high court and the erstwhile act received to the company. As far as the petitioners are subsidiary of the company, here it comes the crux. Both the transferor company, both the petitioner transferor company are the subsidiary of the company going by the name Equitas Holding Limited. So there was a holding company, and that holding company has applied to the RBI in order to seek in principle approval to establish a small finance bank. I must say, now to carry on the business, to have a small finance bank, there is a mandatory requirement that RBI should issue a license. RBI has granted an in principle approval. License is going to be issued subject to the fulfillment of the condition that on sanctioning of the scheme of this amalgamation. Now, this application was made by a holding company to the Reserve Bank in consonance with the Section 22 of the Banking Regulation Act and guidelines dated this. RBI, while its communication dated 7th October 15, granted in principle approval subject to certain conditions which entirely are required to be proposed merger of the transferor company 1 and 2 with the transferee company to be effective prior to the commencement of business of SFB. That means it was clearly stated that the license will be issued subject to the condition the scheme will get the approval from the High Court. The in principle approval was valid for 18-month validity period. You can say the RBI has granted 18-month validity, that within this validity time or within this validity frame, the scheme must get the approval from the High Court. Now, here the RT has raised a concern. RT has raised the following concern, that the scheme does not fix any appointed date, and that in its definition under clause 1.2 of that particular scheme is tied with the definition of effective date. That means, what I mean to say here is, it is totally depending upon the holding company will be eligible to carry on the business of small finance bank subject to the issuance of license. License will only be issued in case license will only be issued if this particular company, license will only be issued when the scheme will get approved by the High Court. And the scheme was supposed to be approved by the High Court within the validity frame of 18 months from the date when this petitioner, when this holding company has got that in principle approval. So RD has raised a concern that scheme does not fix the appointed date, and that its definition under clause 1.2 of the scheme is tied in with the definition of effective date. So yahan pe effective date is a date from which it is considered that is going to be the appointed date also. In this context, the RD awares that the effective date as defined in clause 1.7 provides that it would be the working day. Now, it would be the working day immediately preceding the date of commencement of the business of the bank by proposed SFB. Effective date kya mana gaya ki when you will be eligible to commence the business of small finance bank, usse pehle wala din, which should be a working day. The RD raises a concern that there is no clear date fixed in the scheme which would work as the effective date. So it was, see, it is required under section 230 subsection 5 that the NCLT generally insist upon the registrar. NCLT also insist upon the companies to issue notice to the regulator, ROC, Regional Director, in case transferor company is going to dissolve without winding up to official liquidator also. So RD has raised this concern that there is no date fixed in the scheme which would work as the appointed date. Or effective date unhone kya dala tha, when the holding company will be eligible to carry on the business as a small finance bank, usse ek din pehle, which should be a working day. The second concern was with regards to the same. RD has raised a concern, that is, the second concern expressed by the RD is also linked with the effective date, inasmuch as where the scheme immediately does not articulate as what would be the share exchange ratio. Now, share exchange ratio, we used to take the valuation of the registered valuer as on the appointed date, but here the appointed date is not there. It goes on to state that it would be arrived at the based on the book value of the shares of the petitioner company as on effective date. So here the appointed date is based on the effective date, and it is based on the contingency. Why it is so? The reason is there is a huge possibility that scheme may not be approved by the court. If the scheme is not going to be approved by the court, the in principle approval which you have received will be of no use. When it will be of no use, you will not be in a position. The holding company will not be in a position to get license. And in absence of license, it will not be possible to carry on the business as a small finance bank. So it is based on the contingent event. The third and the last concern of the regional director, which in a sense is also connected to the effective date. It was also connected with the effective date, and in that circumstances, that was the 30th day of the effective date. In this behalf, it is required to be noted that both the scheme as well as the prayer made in the petitioner in the alternative states that the transferor 1 and 2 would make a separate application. Now, यहाँ पे ऐसा कहा गया कि effective date के 30 दिनों के अंदर the transferor company will separately make an application in order to get the order of in order to get the order of dissolution without winding up. Now, this is the case. I said this is the case. Quite clearly, in the circumstances, the scheme can neither provide a clear appointed date nor can it fix a share exchange ratio. What add a further twist to the situation is that the scheme by itself cannot provide for dissolution of the transferor company. Scheme itself does not provide the dissolution of the transferor company without winding up, perhaps for the same reason, which is there is a possibility that RBI may not issue license to the amalgamated company or the merged entity. Now, that was the ultimate reason wherein the appointed date was not a calendar date and it was a contingent date post to the issue of the order passed by the High Court. I said, now therefore, having regard to the aforesaid, what is required to be noticed are the relevant provision in the scheme. It is noted that the appointed date as the effective date. Here, the appointed date was based on the effective date. The scheme goes on to define in clause that effective date at the working day, which is immediately preceding the date of the commencement of business by the bank as a proposed small finance bank. The reason is everything was dependent. Quite clearly, the commencement of the business of the proposed SFB is dependent on the banking license being issued by the RBI, which in turn, depending upon the scheme being sanctioned. Now, everything was dependent. That's why they have put a appointed date in a futuristic event. The reason was the commencement of the business of the proposed SFB was depending upon the banking license being issued by the RBI, which in turn depending upon the scheme to be sanctioned. What need to be clarified by this is there is no standard rule that what amounts to the effective date, but recently MCA has clarified this particular position, and it is stated that now this is the MCA, you can say clarification with regards to this through its general circular dated 21st August 2019, wherein MCA has clarified this appointed date versus effective date. The scheme of arrangement is usually a conditional upon the satisfaction of specified condition, which was there in this Madras High Court decision. I said the scheme of arrangement is usually a conditional upon that satisfaction of specified condition. The date on which the condition to the scheme are satisfied is referred to the effective date of the scheme. Scheme often provide that once all the conditions are satisfied, they shall deem to be the effective on an identified date, which is not necessarily the same as effective date. So this is usually referred to as an appointed date of the scheme. Accordingly, while the condition to the scheme are satisfied on an effective date, the transaction under the scheme are deemed to have occurred on the appointed date. So this clarification which is brought in by this ministry is that enabling provision which allow that company to decide an appointed date from which the scheme will come into force. The date may be a specified calendar date or may be tied to the occurrence of any event or fulfillment of any precondition or other requirement agreed by the parties. So this is the clarification brought in by the ministry. It is provided that it can be a specified calendar date, but make sure that calendar date should not be earlier than 1 year prior to the filing of that application. And if it is 1 year prior to the filing of that application, then you need to state the reason thereof, that why we have set forth a date as an appointed date a year prior to the date of filing of this application. It can be tied to the occurrence of an event jo humne dekha, or fulfillment of any precondition or other requirement agreed by the parties. Now, I've seen in one of the case wherein the NCLT has passed an order sanctioning the scheme of amalgamation, but the appointed date was altered. The appointed date was altered with this opinion that appointed date and the date of the valuation, there is a huge difference between this 2 days. So without informing or without specifying this particular fact, the scheme was approved, but the NCLT in its order has altered the date, and that is the date of appointed date. Now it was happen in one of the case. Here it comes, and that is SLS Solutions Private Limited versus Free Charge Payment Technologies Private Limited. In that circumstances, the NCLT Delhi has sanctioned the scheme of amalgamation, but has altered the date. That is the date what we call a appointed date. The appellant filed this appeal against the order dated Feb 2020 passed by NCLT Mumbai bench connected with this, whereby allowed the scheme of amalgamation of free charge payment technologies and however modified the appointed date from 7th October 2017 to 1st April 2018. Now in this case, the scheme has clearly stated that the appointed date is going to be the 7th October 17, but while sanctioning the scheme, NCLT has altered the appointed date to the 1st April 2018 on the ground that the considerable time has been lapsed from the appointed date as mentioned in the scheme and the board resolution of the scheme, which is dated 27th of March 2018, and the valuation report dated 22nd March 2018. So appointed they have set forth in October 2017. The resolution with regards to the approval of the scheme was passed in the March 18, and valuation was taken a week prior to that board resolution. Now in this case, it is clearly stated that tribunal would not sit in appeal over the commercial wisdom of the parties who proposed and approved the scheme if the scheme is otherwise in accordance with the statutory requirement. In thereby, again, matter comes to the commercial wisdom, because if this date will be altered, it shall render all the calculation useless. None of the shareholder has opposed the appointed date proposed in the scheme of amalgamation, meaning thereby NCLT does not have power to pass an order, and by altering the date which was decided by both transferor and transferee company, if NCLT do so, in that case the question will comes to the commercial wisdom again, and in case if the appointed date shall be altered, it will impact the calculations useless, since none of the shareholders or creditors have opposed to the scheme of amalgamation. Now, one more thing, whether the investment of the transferor company in some third company, see, as far as the merger is concerned, the asset and liability of the transferor company is going to be the asset and liability of transferee company, meaning thereby the investment of the transferor company in XYZ company, now it will be considered as an investment of transferee company. So question arises whether it amounts to a transfer or a transmission, because by the way, pursuant to the scheme of the pursuant to the order, pursuant to the sanction of the scheme of amalgamation by the honorable court or tribunal nowadays, it is by the operation of law, all the assets and liability of the transferor company are considered to be the assets and liability of transferee company. But the question which comes is the investment the investment in securities or the transferor company was having in some XYZ company, now it is going to be the investment of the transferee company. So whether any security transfer form is required to be executed or not. So that is also a question whether it amounts to transfer or whether it amounts to transmission. If it is amounts to transfer, whether any separate securities transfer form is required to be executed or not. So there is a judgment in this connection. Here it comes. The transfer of shares under a scheme of amalgamation, is it a transfer or transmission? Now here it is the Kolkata High Court which has clarified this particular issue. One of the common confusion in case of merger amalgamation is, see, as far as the transfer is concerned, it was governed under the erstwhile Act 108 in the current Act section 56(1). And there is a mandatory requirement that there is a share transfer form is required to be executed. So when the investment in XYZ limited company, the investment of the transferor company is going to be the investment of transferee company, whether any such kind of share transfer form is required to be executed or not. If it is not, whether it is by the operation of law, yes, then whether it amounts to transmission, no. So one of the common confusion in case of merger and amalgamation is with respect to the transfer of shares and investment of the transferor company in the transferee company. So the transferor company was holding some investment in Tata or Reliance or Zipla or Cadila. Now that investment is going to the investment of the transferee company. Now the amalgamation scheme is approved by the shareholder, followed by the court order. Therefore, the transfer of asset and liability is the essence wide operation of law. Generally, wherein the operation of law comes in between, we used to call it transmission. But it is clarified that upon the scheme of amalgamation being sanctioned by the court, the transferor company ceases to exist, and all the assets and liability, including share held by transferor company in third company, get transferred to the transferee company. The question that arises at that point of time is whether any transfer deed is necessary for exercising transfer of share of investment of transferor company pursuant to the scheme of amalgamation, or there is a transfer of share in case of transmission. Here it is clarified by the Kolkata High Court in Messrs. SEBI Properties Private Limited and others versus Shri Pavan Kumar Budhiya and others, wherein the court held that the transfer of share under the scheme of amalgamation from one company to another company should be considered as a transfer and not transmission. The reason is cited below. The Honorable Court of Kolkata held that the transfer of share of the third company pursuant to an order sanctioning the scheme of amalgamation does not require compliance under section 108 of the old Act or 56 of the current Act. The scheme of amalgamation involves the transfer of asset and liability from transferor company to transferee company, but there is a distinction between that transfer of the share inter vivos and transfer of share pursuant to the scheme of amalgamation. There is a difference between the transfer of share inter vivos or the transfer of share pursuant to the scheme. In case of simple transfer between two living persons, the transfer is complete when the statutory compliances are fulfilled, that is lodging of share transfer form with the company. Whereas in case of merger, the property of the transferor company are transferred to the transferee company upon sanctioning of the scheme of amalgamation by the court, subject to the order sanctioning the scheme being filed with the registrar of companies, but it does not mean that transfer of the property from the transferor company to transferee company pursuant to the scheme amounts to transmission. Even though it is operation of law, that will not be considered as a transmission. And one thing which is clarified here is the transferee company should take all the necessary action to identify, to verify, to reconcile, and to make itself sure that the transferee company's name should be registered as a registered owner in the register of member of that company, the company in which the transferor company was holding share. Meaning thereby, if I will remain silent and if my name will not be registered on the records of that company, the company in which the transferor company has invested, then in that circumstances, on the records of that company, the investee company, the name of transferor company will prevail. That's why the necessary steps should be taken by the transferee company to get the shares which are transferred to it pursuant to the scheme of amalgamation registered in its name. In absence of such action taken by the transferee company, the title to such share would still continue to vest with the transferor company. So that is one of the point. Would not take much time, and I would like to go with one more thing. Yes, we used to call it the asset and liability of the transferor company is going to be the asset and liability of the transferee company, but this is not the fact with regards to the liability of the officer in default. As far as the liability in officer in default is concerned, the board of director of the transferor company shall remain liable and they shall held liable for all the wrong action or for all the non-compliance or for all the mismanagement which was committed in the transferor company. It's a company's liability which will get shifted and not the officer in default's liability. It is there under section 240 of the Companies Act. One more thing is there, in case if the matter is pending before the DRT or some action under the SARFAESI has been taken, then whether that amounts to or that will obstruct the merger process or not. Now that is one of the company, Core Healthcare Limited. Gujarat High Court has clarified this fact, that Gujarat High Court has stated that in this case, higher jurisdiction over the application under 391, 394, notwithstanding that, companies before the Debt Recovery Tribunal or SARFAESI has been invoked in this case. One more thing I've seen generally the regional director raise such kind of queries. There are the violation with regards to the investment and loan, section 185, which prohibits company to grant loan to its director, or there are certain conditions under which the transactions are allowed. So 185, 186, which talks about the investment and loan. I've seen the balance sheets wherein such kind of contravention subsist, and the regional director strongly oppose such kind of approval, or the regional director generally oppose the sanctioning of the scheme wherein the transferor company or the transferee company has contravened such kind of provision. It is clarified in one of the case, Lifeline Industries Limited and Suntech Realty Limited. The Mumbai High Court has held that this are the compoundable offences and the same cannot lead to the rejection of the scheme which are approved by the shareholder. So it is compoundable, meaning thereby if it is a liability pertaining to the transferor company, a compounding application can be made by a transferee company. And if it is compoundable offense and the offense is there in the financials of the transferee company at any point of time, they may either opt for a voluntary compounding or else they can opt for the compounding on receipt of the show cause notice by the Office of Registrar of Companies. So that is one of the point. Single window clearance. So here I would like to say, in the scheme itself, you can put all the things which you want a transferee company to pursue, like change of the name. So no separate application is required to be made. Reduction of share capital, it will be considered as a part of the scheme of compromise and arrangement. Shifting of register office. So I must say, as far as the scheme is concerned, it is giving you a single window clearance. Scheme can have a different arrangement. Mergers, demergers, composite scheme of merger, what we call, reduction of share capital, change in the register office, or even name. Scheme under section 230 and 232 is a complete code in itself. And considering the principle of single window clearance, it is not necessary for the petitioner company to get a separate clearance prescribed under the Companies Act. Commercial consideration, like IBC, here again, the dominance are with the shareholders, with the creditor, who sanctioned the scheme of merger or amalgamation, and on the grounds of this technicalities like swap ratio or the valuation, generally NCLT or ROC or RD or OL does not interfere. But there is a ruling which has been made by the NCLAT, which is quite opposite to Mihir Mafatlal case, wherein NCLAT has stated that they will not only acting as a reviewer or overseer, but they can also adjudicate on the commercial wisdom. So that is one of the case. Rather than taking much of the time, I would like to say again, there is a confusion with regards to the merger of LLP with the company. There was one order passed by the Chennai bench, and that was the reason there were many inquiries which used to follow that whether we can have our LLP amalgamated with the company or not. As far as the LLP Act is concerned, LLP can amalgamate with the LLP. As far as the Companies Act is concerned, a company can amalgamate with another company, but there is no prohibition with regards to the fact that LLP cannot amalgamate with a company. But there is a slight difference under the old act and under the present act. In the 1956 Act, it was the body corporate which can merge with another company or a body corporate, but here the word body corporate has been replaced with the word company. So Companies Act 2013 provides for the amalgamation of company with the other company. On the other hand, LLP Act 2008 provides for the amalgamation of LLP with the LLP. So cross merger between company and LLP is neither permitted nor specifically prohibited, whereas the merger of foreign body corporate with Indian company is specifically permitted. Now, NCLT Chennai has taken its own view. There are two significant orders which has passed in this regard. The significant judgment is with regards to merger of Verti's Microsystem LLP with Forge Hat Solutions Private Limited. This is the case which was pending before the court, and then with effect from this enactment of this section 230, section 232, the matter has been transferred to NCLT. So this is the merger of the Verti's Microsystem LLP with Forge Hat Solutions Private Limited, and the second one is with regards to Real Image LLP and Cube Cinema Technologies Private Limited, Chennai. अब NCLT Chennai ने जो order pass किया था, the rationale of NCLT Chennai was that under the Companies Act 56, there was an express provision wherein the transferor company included any body corporate. However, there is no similar provision under the Companies Act. So in the old act, the wording was the body corporate can amalgamate with a company, wherein the word body corporate has been replaced with a company. So the body corporate is not presently under this current act. Now there is in this circumstances, the merger of the body corporate including LLP with the Indian company was categorically covered under the 1956 Act, there being no specific provision under this current act to provide for the same. It was reckoned to be a case of casus omissus. That means a case where the omitted to be included. The case where the omitted to be included, but which would otherwise have been included given the same was specifically provided in the erstwhile act. So meaning thereby Chennai NCLT has put this kind of base. It was reckoned to be the case of casus omissus, wherein a case which was omitted to be included. The case which is omitted to be included in this current act, but which would otherwise have been included given that the same was specifically provided for the erstwhile law. So it's ground way. On this ground, the Chennai NCLT has passed an order with regards to the merger of LLP with a company, that is with regards to the Real Image LLP with Cube Cinema Technologies Private Limited, but is both challenged. NCLT has reversed the order of NCLT Chennai for merging LLP into company, meaning thereby now the choice is if you want to convert your LLP into, if you want to merge your LLP into company, you need to convert your LLP into company, and then only company can amalgamate with another company. I would not like to go much further, and yes, this is the last point I would like to say, whether any pending investigation can obstruct my merger or not. Now, in this case, there was a company, demerging company, wherein there were two different units of that demerging company, and these two demerging units were proposed to be demerged with another entity. But there was investigation which was going on. The investigation was going on in the demerging company, and the investigation was going on in that unit which was not proposed to be demerged. So whether on this absolute case whether NCLT can reject or can deny or not. So judgment was quite clear. Yes, judgment clearly states that as far as this judgment is concerned, it is clear that the scheme can always be sanctioned subject to and without prejudice to the liability, if any, in the civil and criminal proceeding in respect of the past transaction. So investigation shall not hinder your demerger, specifically when the unit which is about to be demerged has nothing to do with that investigation. It is provided that business of the mining which would continue with the demerged company and the pending investigation would continue unhindered against the director of the demerged company without any impact on the proposed scheme of demerger. यहाँ पे जो company था, इसका जो mining unit था, the mining unit was proposed to be continued by the demerged company, but उसके बाकी के जो दो units थे, one was with regards to wind energy generation and other one was with regards to real estate. So those two units were proposed to be demerged, and the company which was willing to retain its business, that was pertaining to the mining unit wherein the investigation was ordered. So when the investigation was pertaining to that unit which was not proposed to be demerged, and hence it will not considered as a hindrance to the approval of the scheme of amalgamation. And one more section which can come in between is section 240, which clearly states that even after the amalgamation, that will not give any kind of waiver with regards to the liability of the transferor company's officer in default. Liability of the transferor company is going to be the liability of transferee company, but that will not impact the liability of its officer in default. Second thing is, in the first stage, in the first motion application, NCLT does not go into this much merits. In the first stage application, NCLT generally passes an order with regards to either dispensation with regards to the holding of meeting, or else NCLT direct for calling up of the meeting. And the views of the shareholders and creditors are ultimately the base on the basis of which the second motion application get adjudicated by the NCLT. There are many such kind of judgment as far as this merger or amalgamation is concerned. As far as the Stamp Act is concerned, as far as the taxation part is concerned. So this is endless topic, but considering the time constraint, it's always better to hand over this mic, because now the another topic is quite interesting, and that is with regards to the compromise and arrangement, which generally happens in case of the approval of the resolution plan, and even in absence of the approval of resolution plan, there is a possibility to enter into a compromise and arrangement with another party and to get the companies bounce back from insolvency to resolution. So would like to hand over this particular session to the moderator now.
Vinit bhai, are you able to see my screen?
Yes, it's visible.
Yes, sir. Yes, sir. So we welcome our second speaker, Advocate CA Nipun Singhvi bhai. We have called so many times on our platform. I think I lost the count as well now, Nipun bhai. And you accepted our invitation all the time. Thank you so much, sir. And would like to tell that despite of your illness a few days back, you and the Vinit bhai both, this session is possible with the president of ICSI and Central Council member Praveen Soni sir. So कहते हैं ना कि कुछ होना है तो अच्छा ही होगा. So this is a good example of that. So our merger and acquisition series also will be end with this session also. So thank you so much once again, Nipun bhai. And the president sir has already introduced and appreciate the effort of yours taking session everywhere. West, obviously, because you are from West, North, South, East, everywhere you are taking session, and that is your example. And not only on one topic or two topics, there are number of sessions you are taking. And recently we have a session on Right to Information Act, which is very unique session. So thank you so much, sir, for all the efforts. and would like to request now to take the proceeding, guys. Thank you.
Thank you, Virag Bhai, for so kind words. And thank you, Nagendra Rao, sir, also, because I suppose I have met him only twice. And it was wonderful sharing and interacting with him. In fact, he called me that you should also come out and practice in South. But I said, sir, I am a single person, not being able to cater the whims of North only. So how to come to South? But I think that now I have a very good friend here, Vinit, who is vibrant and dynamic enough to take things forward. So I think now we have a bit easy work to go. He has already simplified the topic, the amended topics, and very good case laws he has already taken. In fact, I had deleted some slides while seeing his presentation because those case laws he has already discussed. So I was actually trying to take some case laws, but he has actually done the Sachin Tendulkar part. He's already covered the most important judgments. What I will now try to do is I will try to focus on some other aspects of M&A which are very much relevant in today's scenario, because nowadays M&A has become not only limited to Companies Act. It has forayed into, I would say, insolvency code. It has also forayed into competition law. Now it is interplaying with different laws. Therefore, M&A activities have increased. In fact, in the lockdown, the report says that M&A activities have doubled, which it was not doing normally. So in M&A, what has happened is many of the companies which have got distressed due to COVID and all, they have now tried to revive themselves and try to capture other corporates from the same segment. So therefore, this particular topic is very interesting. And recently we have seen the Videocon case also just a week back, that it has been acquired, or I would say took over by Vedanta Group. So how that is also interesting. I would just throw some light on that. Before that, I would like to first focus on some of the issues which would leave us with some thinking that M&A proposals, though some people say that M&A is more of a compliance nature, and if you file an M&A before NCLT, 99% chances are it will get approved, maybe with some modification or not. But there are very few cases in which NCLT and NCLAT have rejected the proposal of merger. So I'm going to touch upon such few or some rare cases where it has been rejected, because when you do practice, you have to be very much aware that what are the cases in which I can actually end up failing the activity which I'm trying to propose, or maybe some of the safeguards which we should know as a practitioner or as a client, that these safeguards, if I do not take, then probably my client's scheme may get hampered. So some of the safeguards which I have jotted down and which I think are very much important to first plan before that, when we are going for an M&A, whether these particular parameters are there or not, or whether these parameters can be a ground for rejection. Now, M&A, as the name suggests, and Vinit Bhai has taken it in very great detail, what does the M&A actually mean? What is the perspective? I would like to tell you that the word merger, that the word acquisition, technically is not there. The words in the Companies Act, it includes merger, it includes demerger, it includes arrangement. So the scheme of arrangement is the word which is there in the Companies Act. Now arrangement includes everything. It includes merger, it includes demerger, but there is no word called acquisition under the Companies Act. So that is one thing that we use sometimes fancy words just to put the topic forward. But when you see the law, some words are missing, and therefore sometimes we have to be very cautious while explaining a particular topic, whether that word finds place in the law or not. Similarly, demerger word is not there in the Companies Act, and therefore it is there, but it is not defined. The definition of demerger is given under Income Tax Act. So I will take you through some of the nuances which we need to take care while practicing in M&A or while advising an M&A transaction. Now, first we will discuss these parameters, and then I would couple these parameters with insolvency law, that how a distressed company can be taken over by a healthy company through the process of M&A, and therefore the benefits which are normally arriving through takeover would increase. So the first one is the parameter which broadly we would discuss is tax evasion, whether a particular scheme can be said to be evading tax, whether it can be rejected on this ground, whether a scheme whereby minority shareholders are suppressed or their rights are suppressed and there is some objection, and whether that objection can be sustained and that scheme can be rejected. Third one is whether in public interest a scheme is said to be accepted or not. Suppose a central government moves a scheme for merger, can that be challenged? So recent Supreme Court judgment also we will discuss with regard to National Spot Exchange Limited. And the last one for which all the M&A activities is done. So most of the M&A activities is done for getting synergy, getting benefits. So obviously with respect to resources, with respect to synergies, M&A is a very big area. But ultimately, what is the benefit which we are going to get in the books? So the best part of M&A activity, or I would say the most luring part of an M&A activity, is the tax benefits associated with the M&A activity. So we need to sit down with a tax expert and then only plan and scheme, because without a tax expert, M&A is like without the soul. So tax benefits is something for which everybody wants to go for M&A, because a loss making company can be absorbed by a profit making company, and there could be a direct benefit of 30% which otherwise would not have happened. So these all situations have led to increase in the M&A area space. So the first one, or I would say the interesting case whereby the first time income tax department objection was sustained and the scheme of merger was rejected by the tribunal. So there were, if most of the professionals hearing me would be aware about the GAAR, General Anti-Avoidance Rules. So the GAR provisions which were introduced in income tax said that if there is a scheme whereby it is to avoid tax or to evade tax, then that particular scheme should be held to be a tax evasion scheme and should not be allowed. As we are aware, as Vinit Bhai has already told, what are the procedures to take the M&A activity, we always serve the scheme to the income tax department, because that is a department which is a compulsory department. Just like we serve it to ROC, RD or other regulators, income tax department is the main department which goes through the scheme and raises objection. Now, income tax department in this particular case raised objection that the particular scheme of Ajanta Pharma Limited, whereby the merger was being proposed of GIPL, that was the Gaps Investment Private Limited, with AJL, only led to the benefit of promoters. So I've just tried to draw some diagrams and I've taken help of some sources. I've already given them credit in my slide. The diagram, if you see, clearly shows that there was a promoter family, Mr. Agarwal's family, who indirectly held stake in AJL, that is Ajanta Pharma Limited. So indirectly through GIPL, they were holding 9.53% stake. Now this particular stake which they were holding, if the merger took place, it was a tax-free, or I would say tax-neutral merger. What was happening was Mr. Agarwal's stake was getting increased without paying any tax. Now, if this scheme was not there, what would have happened? See, the scheme was like this. So if the scheme was not there, Mr. Agarwal would have to pay either capital gain on the investment in GIPL, or he would have to pay dividend distribution tax if the company was closed. So the assets would go to the promoter family or to the shareholder family, thereby a dividend tax would be paid. And this particular transaction would have been giving money to the department. Now, this particular scheme of merger was in a way avoiding that particular tax which was to be paid by the shareholder. Now, please understand that a scheme may be compliant with company law, but may not be complied with income tax law. There could be a situation where the scheme could be objected, or there could be some tax demand which is coming on because of the scheme. Therefore, I said the first thing which we need to do is sit with a tax expert while drafting the scheme, while thinking that this particular creative transaction to avoid tax or to do a tax planning. So let's understand what was the logic behind this particular rejection. So they said that Income Tax Act, the department took a plea that you are using the provisions of Income Tax Act in such a way by using this particular trick, or I would say a scheme, to avoid the tax. So this particular argument was accepted by NCLT, and it said that there was no public interest involved, though Ajanta Pharma Limited was a listed company and this was a private limited company, the GIPL and the shareholder stake which was being merged, the benefit was going only to the promoters. There was no public interest involved, and therefore this particular arrangement by which a stake of particular promoters was only increased, no public interest was being served, is rejected. Now this particular rejection was then obviously challenged in NCLAT, but as per their own annual report, they had withdrawn the NCLAT appeal after weighing the rights, obligations, cost and benefits involved in this particular scheme of arrangement. So what should be our logic to avoid such type of a situation? So I think the first argument should be that the income tax, if at all, thinks that this particular arrangement is not as per law or it is to avoid tax, they can always take recourse under Income Tax Act and the tax can be paid. Now here you need to have a call with the client that tomorrow such type of arrangement, if objected by Income Tax Department, should we give an undertaking that we would pay the tax? So technically speaking, if this arrangement was not to avoid tax, they could have very well taken an undertaking and said that we would pay tax, you allow the merger. But if that was the only intention, probably the argument was correct that they would not go forward with the scheme. So we have to weigh every time the scheme, what are the benefits, what is the cost involved. So if the benefit was only to avoid tax, then obviously such type of schemes will not pass through the muster. And previously the argument which was there that court has to see only the judicial part, court cannot go into the technicalities of the scheme, is now, I would say, diluted or taken away, because now NCLT or NCLAT, they have a composition of a judicial and technical member both. So now the technical member usually who understand accounts, finance and tax, probably they will be able to appreciate the objection taken by the department. So therefore such type of arguments of Income Tax Department will have to be considered and factored in our scheme. Such type of cost should also be told to the clients. Now there are two important things which in my personal opinion, or I would say the consultants or professionals, which we think that should have been put in this particular transaction, because obviously now this transaction did not go through. But if these things could have been pleaded, probably it could have passed the muster. Like CBDT had issued a circular clarifying the GAR provision that for raising a GAR provision allegation, it has to be an impermissible avoidance arrangement. Now what is impermissible avoidance arrangement? There are four factors which you would see on the screen, that these four factors should be taken into care, and it should be first vetted by principal commissioner and then by a panel. So I don't know the facts of the case, whether this was done in particular case or not. We are not clear whether this has been done or not. But in my view, the timeline which is given as per the act is 30 days to the department. Now in 30 days, whether this procedure was complied or not, this is not done away with. But if you really want to fight on this particular aspect, you will have to present your case before that panel, and you could satisfy the department that this is not a tax evasion structure. So that is one of the important part which we should consider while planning, that whether we are trying to do a tax planning or we are trying that some tax may be saved and this may lead to tax evasion. Second case which I think is very important, and nowadays this is happening, that is the case of this Bank Security Limited. What had happened in this case? Again, this is a negative case where the scheme of merger was denied. Why it was denied? Because one of the companies, which was the applicant company, was being merged, which had only investment. There was no substantial income otherwise. So the objection raised by the regional director was, this is an NBFC, because there are two parameters to consider a company as NBFC. 50% income and 50% asset should be financial. So if these two tests are met, then it's an NBFC. Now the argument taken by the company was, we have substantial investment, we have income, but that income is not coming from investment. Therefore, financial income is not 50%. Now the question which was raised by RD was that even if there is no income or there is a zero financial income, can you say that this particular criteria of 50-50 is not met? Because in 50-50 criteria, the logic behind this RBI circular is that a company which is only into investment or giving advance or giving loan or taking loan, in a way is an NBFC, because it touches the 50% criteria in asset side and 50% criteria in the income side. Now this particular matter was rejected by NCLT, and thereafter it went to NCLAT also. So what had happened was, both of them, NCLT and NCLAT, they had accepted the RD's contention, and they put a question before the company whether you can declare that this particular company is not into investment business, loaning business, whether can you declare that the income which is appearing in the P&L account is not coming from investments. So because of these absence of these two parameters, now the logic particularly for this particular case is, whenever we are applying and if there is an objection like this, we need to first check our balance sheet, first check our P&L account, and check with the RBI that whether this is an NBFC or not. Because the interpretation taken by NCLT in this particular case is, if the financial income is zero, but if the investment is more than 50%, then also this will be a deemed NBFC and you need to take RBI approval. Now, in such a case, even if you go to RBI and RBI says we have no objection, then the matter is over. Then there cannot be an objection to merger. But once an objection is raised by RD, we have to be very cautious to clear that objection, because that RBI is also one of the regulators if a company is an NBFC. Now, this is not a plain vanilla NBFC, but it could be the case of deemed NBFC. So therefore, this particular parameter also we need to consider. And suppose tomorrow it is an RBI says that yes, it is an NBFC, you need to comply. That additional cost will also come onto your scheme of arrangement. So that is another important case where we need to factor in the cost of a regulator who is coming in the way. Now, though I have already taken the first judgment, and I think Vinit Bhai also covered this judgment, it's a judgment of WikiKids Limited, where also the same issue came that the public interest was not served and the amount was going only in the hands of promoters. In fact, some of the issues which were there in the particular case, I'd like to point out that there was 95 lakh rupees were spent from the share capital, which was only 117 lakh. So basically out of 1 crore 17 lakhs, 95 lakhs was already spent. So 22 lakhs was only the value of the company which was getting merged. So the point here was that the company was getting merged. It did not have worth, and they were being paid 12.4 crores to the shareholders of those company. And that particular company which was getting merged was worth only 22 lakhs as per the balance sheet. Therefore, the court was not satisfied with the share exchange ratio, with the valuation report, and court held that since the public interest is not getting advanced, it is only a private interest, only going to promoters, then we would not allow. Again, in this case also, the entity in which they were getting merged was a listed company. Therefore, this parameter of public interest is there. See, if two private limited companies are getting merged, this argument will not come into play. Now, another important case whereby there was a central government order to merge the entities, or I would say it was a forced merger, has been set aside by the Supreme Court. So this is again a very, very interesting case whereby we all are aware about the National Spot Exchange Limited scam. So-called scam, though it is not proved, there are various allegations, but central government had brought out an order under section 396, 391 to 394, the erstwhile Companies Act, and asked for the merger of these two companies and said that it is under public interest. There was no objections being invited by the creditors, no objections from the shareholders. So this is for the first time whereby the Supreme Court interpreted the word public interest, whether it was essential and whether it was in public interest. So one of the issue which was raised was that there was no objection being invited from the public, and simply an order was made, and therefore the order needs to be uh, upheld because it's a central government power to give such an order, and this is an administrative order which court held, and it cannot be taken to be a judicial order, and therefore merger was set aside. Second important thing in this particular case, because obviously such type of cases are case specific, one of the issue was the objections were not invited. Second case was the allegation which central government has accepted and merged the two entities, saying that crores of rupees have been due. You cannot force liability of X company on Y company, and therefore the logic is you cannot burden the shareholders or creditors of a company which is healthy by an unhealthy company without asking their objection, without asking their right to get an exit from the company. Therefore, the public interest also will have to be seen from both angles for both the companies, transferor and transferee company. So therefore, in such a situation where only one company is getting benefit and other company is not getting benefit, such type of public interest orders cannot be upheld, and therefore Supreme Court set aside this particular order of forced merger. Interestingly, this was approved by Bombay High Court. So Supreme Court reversed the judgment of the Bombay High Court. So this is very important case. Now another case, very interesting case, and we all are aware about Reliance Jio. They have been doing number of scheme of arrangement, I would say, sometime merger, sometime demerger, sometimes some creditors being assigned to one company or the other. So one of the cases where a composite scheme was filed. So this is an NCLT Ahmedabad case where there was a demerger of optical fiber in one of their companies, slum sale of tower business in another companies. So basically this arrangement was done where demerger and slum sale was effected. Secondly, they converted preference shares into loan. So basically, if I am having preference shares, I will have to pay the dividend to the shareholders. Now that dividend distribution tax, I have actually, you can say, avoided. I need not pay the tax because I have now converted them into loan. And when I'm paying for the loan, I will have to give the interest. When I'm giving the interest, same as that dividend, in dividend I had to pay tax, and in interest I will get the tax benefit. So because it is becoming an expense for me, dividend is not below the line, it is above the line, therefore it has to be paid via tax. Under the line, that is an expense. So basically they converted the equity into loan. In simple words, equity into debt. So the allegation by the income tax department was this scheme was a way to defraud the department, and therefore a tax evasion planning, you can say, through this particular scheme. This particular equity converted into debt should not be accepted because ultimately they are evading the tax. Now they could not uh, deliver, they could not object it before NCLT, and they went to NCLAT when the scheme was approved by NCLT. Now NCLAT, after examining the complete scheme, said that this scheme is not only for this particular purpose, it has various benefits. Various units have been divided, or I would say slum sale or demerger or everything has been done with an intention to get synergy, with an intention to divide the business into risk and return segments. Therefore, it cannot be said that the complete scheme is evasion of tax. And therefore, they upheld the order of NCLT approving the scheme, and they did not set aside. However, they said that they can proceed under Income Tax Act if any of the provisions are violated. So therefore, I would say this is a positive judgment where the objections, if at all being received by the department, from the department, they can be handled by saying that those particular objections, those particular violations, if at all under Income Tax Act, will be dealt separately. You cannot come and object to the scheme because scheme is my commercial wisdom. My commercial wisdom means the commercial wisdom of the shareholders. As already Vinit Bhai had explained, the Mafatlal judgment of Supreme Court is a famous judgment whereby it was held that the commercial wisdom of the owners of the company cannot be questioned by the judicial body. Judicial body cannot come inside and say that this commercial aspect what we are trying to do is for evasion of XYZ. So that allegations would get away if you are able to demonstrate that the scheme is the best interest of the business. So that is very important. I have taken contrasting judgments to make things clear, and it will always depends upon the facts of the case whether a scheme would pass muster from the NCLT or not. I'm not saying whatever we think will get passed in the NCLT, but these are the safeguards which we need to understand while planning for a scheme. Now, I'm coming to the core issue. The scheme of arrangement always has some benefits, maybe tax benefits, maybe other benefits of synergy, maybe benefits of resources, benefits of administration. Various benefits come on whenever you try a scheme of arrangement. Now these benefits, I would say quadruple. It gets double, triple, 4 times. What is the reason? Because under IBC, the company comes under distress. So whenever a company is under distress, company is being sold at a lesser price than what the claims are. Now what is the claim? You are aware last week there was a approval of Videocon insolvency got revived. There was a resolution plan by Vedanta Group. Around 96% is the haircut. So you can understand 60,000 crore claim and company going for 3,000 crores. So that is the contrast. Why this contrast? This contrast is because I think most of the professionals watching would be aware about the waterfall of insolvency, but still for understanding, I have just put on the chart that under Companies Act, there were various issues. You had to pay the government the first part. You did not have the sacrifice from operational creditors. Now under IBC, you have the government, I would say, at the fourth pedestal, and you can revive the company by paying the least amount which the company is getting under liquidation. So this is the waterfall on the right hand side of your screen. If suppose the company has taken 500 rupees loan, that is not important. Today the important thing is what will the company fetch if it goes under liquidation. So let's say company has 500 rupees as the claim, but it is going to fetch only 50 rupees. So 50 rupees has to be paid as per this priority. First it will go to the insolvency process cost. Second, it will go to the workers and secured creditors, that is bankers normally, then employees, and then any unsecured FC. In my personal experience of around 500 odd companies, I have seen that the money does not percolate down below financial creditors. Normally, the money is not left to be given to that. That is the reason why the company is under financial distress or under IBC. Therefore, getting a company under IBC is always a win-win situation, because you get a clean slate company as held by Honorable Rajasthan High Court and then confirmed by Supreme Court. The clean slate theory is the basic concept why everybody is going to buy the company under IBC. People are now not going and buy the company just like that. They want that the company should go under IBC and that come back clean from it. Why so? Because all the claims, whether contingent, whether crystallized, whether finalized, will have to be paid only as per waterfall. And once you get the company, all the claims get zeroed. So that is the best part of IBC. So now what we are trying to do is we are getting a company at the liquidation value. So obviously we are going to get something better. Secondly, we are now adding this particular resolution with scheme of arrangement. So scheme of arrangement could be merger, it could be demerger, it could be anything, a combination of both, whereby probably I am merging a company and then also I am demerging one of the entities to be sold elsewise. So there have been a good number of cases now whereby the resolution plan entails merger, demerger, and a combination of both. So what happens of a process, I think everybody is aware, 180 days normally is the process. It could be extended to 270th day, whereby the corporate insolvency resolution process ends. Now when we are bringing a resolution plan, we are trying to revive the company. So this would be done in 270 days. So I'm first taking this part of 270 days. If we fail, we will go to liquidation. Again, in the liquidation, we can again bring a scheme of arrangement. So I am going to discuss both of the parts. So let's understand what is the resolution plan. So resolution plan is a plan whereby you are making the payment as per the waterfall. You are paying everybody. You can pay over and above the liquidation value. You can always pay all the creditors, but normally practically they pay everybody liquidation value, maybe sometimes less than liquidation value. There are some Supreme Court judgment which has come. Maharashtra Seamless Limited is one of them, whereby even a company can be purchased below the liquidation value. So now see, resolution plan means you are taking the company and it is going to be a going concern once you are taking it up. So that is the resolution plan. Now they have clarified, though there were judgments before this also, but they have clearly clarified that you can do a restructuring through a resolution plan. So it could be a merger, it could be demerger, it could be amalgamation. So let's say recently Garden Silk Mills case, though there are many cases, I am just taking one of them. So Garden Silk Mills case, what had happened was the plan has been approved. There is a good haircut to the financial creditors, and by resolution plan they have merged this particular company into another SPV. So the resolution applicant in his plan has written that I am reviving this company, buying this company and merging with another company. So this is possible. Similarly in SR Steel also, ArcelorMittal bought the company and now they have a special purpose vehicle where they are going to merge it. So such type of combination whereby you are already getting benefit of that particular company and thereby merging that company into another will actually benefit both of them. For example, there could be a case where the company in which they are merging is a good profit making company. There would be huge losses in this company. So when there is a merger, you will find in the order also specifically the income tax on that particular profits will get reduced, because the loss making companies carry forward losses, benefit would go to resolution applicant. How that benefit would go, they have specific provision is there under section 79. Normally what had happened was 51% shareholding has to be same, only then loss can be carried forward, but that is an exception to resolution plan. If you are bringing a resolution plan, 51% restriction will not apply, because obviously the resolution applicant, who is the buyer, will always have his shareholding. So previous shareholding will go away. To remove this particular bottleneck, this amendment was introduced in 2018. But I would say it has come into practice now. Now people are utilizing this income tax losses in profit making company. So probably there would be no asset in the company also. In some cases I have seen there are no assets in the company, but the carry forward loss itself is an asset. So as we say that a clock also which is closed shows time 2 times in a day, correct? Similarly, even if a company is having nothing, still the value of the carry forward losses can be taken over. For example, there is 1000 crore loss, and if I get it merged in my company and I am making profit, I can have the benefit of 30% of those loss. So it could be around 300 crores. So the point I'm trying to make is you can also work out a plan to use the losses of a company by merging it with a healthy company. Obviously, you will have to take into consideration the Income Tax Act. I'm not denying that, but the things which are happening in the market, you will have to be aware that how a profit-making company and a loss-making company can be merged to reach the economies of scale. This is a perfect tax planning. There is no tax evasion in this, and you are also maintaining the company, like Videocon company. What they have done is they said that we would delist it. Then 11 companies of Videocon which were under IBC, they have consolidated it, merged it, and now probably, we don't know, probably in the future they might also merge it with their main entity, or maybe they would form a new entity and get it listed. So such type of permutation and combinations are happening. Not only I would say in Videocon or SR or Garden Silk Mills, there are a number of cases in which this is happening. I've just picked up few cases. Now the another important thing in this scheme of arrangement is whether I can bring a scheme of arrangement or not. So if I want to bring a scheme of arrangement, I should not be disqualified from bringing a scheme of arrangement. So this particular chart I have just brought it from IBC law. It is very important chart whereby in SR Steel the promoters were not permitted. So because of this they were disqualified under 29A. But the same thing applied to ArcelorMittal also. They also were disqualified. What they did to become qualified is they had paid some of the dues of the other companies. So a person may be disqualified under 29A, may become eligible by paying those debts, and then he might bring a resolution plan. So similarly, a resolution plan or a scheme of arrangement can be brought by the person who is eligible. Now let's see, if there is no resolution, company goes into debt. So when a company goes into debt, I always say that I always remember this anecdote of Savitri, where her husband actually died. So she waited with him, did not cremated him, and said that I want the life back of my husband. So it's something like this, that a company has died, company is under liquidation. Now how to bring that particular liquidation company back to life? So this particular provision was not there. Similarly, in Savitri's case, there was no object of bringing life back. But when she waited, they got an life back from Yamraj. Similarly, this particular provision also was not there in the original IBC, but it has been brought by various judgments of judicial court, whereby if you are not disqualified, when I'm saying if you are not disqualified, mostly the promoters. If promoters are not disqualified, like in the previous example I told, by 29A, where they are not willful defaulter or convicted or something like this, then they can also bring scheme of arrangement. So scheme of arrangement would probably, in the case of promoters, would be a scheme of compromise, where they might arrange some funds and then pay off all the creditors and then get back the company. So company can get revived even under liquidation. But there is a timeline prescribed in the law, that is 90 days. So in 90 days in liquidation, any person, not only the promoter, he could be a third party, he could be a creditor, he could be anybody, a shareholder also, he can bring the revival of the company, provided he is not disqualified under 29A. See, 29A is a very big section, so I am not going into each and every clause of 29A. In short, in simple words, a person should not be disqualified under 29A to bring a scheme of arrangement under section 230 of Companies Act to revive a company which is under liquidation. So that is very important. Now, interestingly, there is one judgment which has recently come, that is with regard to Asis Logistics Limited. The judgment says that if a company becomes MSME, so probably those restrictions which were previously there on the promoter may get away. MSME, the provisions are relaxed, and under MSME, the promoter can bring a scheme of arrangement. So there could be a life after death. So this is very important, that MSME status has to be checked at the time of giving scheme of arrangement. So probably there could be some promoters who disqualified under the resolution process. Company went into liquidation. Nobody has come to buy the company, but now the company has attained the status of MSME as per the revised definition. So today he can bring the scheme of arrangement. Now some of you would ask that whether scheme of arrangement can be brought only 90 days. So see, recently we had fought a case where the time period had lapsed, 90 days had lapsed, and almost a year had passed, some 10 months or something had passed. But when there was nobody to buy the company and the matter went into appeal also, NCLAT allowed the promoters to bring a scheme, because in this case it was an MSME. They were allowed to bring a scheme, and we have successfully done it, that the scheme of arrangement has been brought under liquidation almost after a year. And therefore I have given the citation. This is a very important citation, whereby the scheme of arrangement has been approved by the court. Now that creditors and shareholders also have approved, and now it is at the second stage. So probably we will get a good order, whereby even after a year the scheme has been allowed. So basically NCLT has the power to relax the timelines also. Ultimately the object is to revive the company. Now some of the issues which I have not touched in greater detail, but I would like to put some posers to you. One is, whenever two companies or more than two companies are getting merged, it is very important. And when I'm saying merge, I am saying all the scheme of arrangement, merge, demerge, amalgamation, everything. So if they are doing so, there is possibility that there is a regulator. Let's say Vodafone and Idea are getting merged. Then in that case, Department of Telecommunication will have to be gone. They have to be sectoral regulator. Competition Commission of India will have to be approached. If the market is, if the limit, they have 250 crore and 750 crore as the limit for turnover and assets respectively. So that limit, if it is getting a hit, then also a prior approval from Competition Commission of India has to be taken. Sun Pharma Renbex is a very important case where the merger was allowed. subject to CCI conditions. So there could be a case like this. Someday we might discuss CCI also, but CCI is a very good regulator which actually sees that there is no anti-competitive measures being taken through merger. There should not be a situation where there is only a one telecom company and there is no other telecom company and the prices are touching sky. So that should not be the case. So CCI is a watchdog which maintains competition in the market and kills the anti-competitive measures if it is taken by any of the company. Ultimately, it is for the benefit of consumer. So I have given an example of Sun Pharma Ranbaxy with regard to merger where CCI node was taken. Vodafone Idea, in addition to CCI, Department of Telecommunication node was also to be taken. Then tax benefits is something which I have already told you need to consider while going for a scheme, whether change in shareholding will happen, whether carry forward of losses would be there or not, whether demerger is as per the Companies Act or Income Tax Act. So just by writing in the scheme that we are doing demerger, it will not suffice. You have to specifically mention that you will adhere to the conditions in the under Income Tax Act, because Income Tax Act specifically defines demerger, gave some condition. Until those are met, demerger, even if it is under Companies Act, even if it is approved by NCLT, will not give you those tax benefits. So depending upon the business, depending upon the permutation and combination, probably we will have to think of merger and acquisitions in a way that whatever law we are going, whether it is simpliciter under Companies Act or under IBC or under different law, the purpose is achieved. Companies Act is a parent law, but you will have to see what new forms other law are interplaying, and therefore it's a very good and emerging area of practice for all of the professionals here. So I think Virag bhai, I have completed my deliberation. In fact, I think Vinit bhai may also come in so that if there are any questions, we both can take. Virag bhai, are you there?
Yes, sir. So Vinit bhai, I think taken a few of the question during your session, and you also taken. So most of the people asking for the presentation, sir. Sir, there is one question from Mukunji. Sir, during merger, one company is bound to benefited, otherwise who will exercise such option? Mukund Puranik ji is asking the question.
Vinit ji, you may take.
I must say that survivor is always going to be the beneficiary. In absence of any benefit, this is a procedural aspect, considering some cost, considering some expenditure incurred. Say, as far as the company which is going to merge with another company, of course, the company with which the first company is going to merge will be having the benefits, either of the losses or else the technology transfer or else the licenses, permits, or the assets. So absolutely, beneficiary is going to be the transferee only.
Thank you, sir. There is a question from Sandhya ji. Where there are so many safeguards built in M&A, how come DBS acquired Lakshmi Vilas Bank completely by wiping off the value to the equity shareholder?
So this question I would like to take. In fact, Sandhya ji, if I had time, I would also share the RTI. I had applied RTI with Reserve Bank of India, whether they had taken any approval for NCLT, whether they had actually discussed or not. So the reply came that they have gone by private sale only. They did not do a public auction, and they used their powers under Banking Regulation Act to take over the DBS, to take over the Lakshmi Vilas Bank and sell it to DBS. And interestingly, the scheme was only for 2.5 days uploaded on the RBI website. Now the matter has been challenged and it is pending before Supreme Court, because various high courts, they had challenged this particular scheme of a merger, and they said that this is not correct way, that RBI can take up any company and sell it. And I think probably the judgment of FTIL and NSEL, which we had discussed, where the central government had taken an order and it was then set aside, maybe it was a 2013 order and it took almost 8 years to set aside by the Supreme Court. Probably something like this may happen in the case of Lakshmi Vilas Bank also. So I agree with you. There are so many safeguards, still they have bypassed everything. And in my view, in my personal view, it is incorrect.
Right, sir. Thank you, sir. Next question from Shweta Agarwal ji. What is the treatment of shareholding in transferee company while calculating value per share and determination of swap ratio?
Vinit ji, please.
You please repeat the question.
What is the treatment of shareholding in transferee company while calculating value per share and determination of swap ratio?
See, as far as this valuation aspect is concerned, it again varies from the requirement. I've seen as far as the valuation aspect is concerned, the registered valuer are the ultimate authority on the basis of which the valuation are required to be taken. As far as the transactions are concerned, at which value they are getting the maximum benefit in aspect of the tax, in aspect of accounting, transferring the amount to reserve, whether to general reserve, whether to capital reserve. I must say, as far as the valuation concerned, registered valuer is the ultimate authority. They can specify this fact that how the valuations are treated pre-merger, post-merger. I must say this is the technical part, and the valuer or the chartered accountant may probably answer it in a right fashion.
Right, sir. Right.
Nipun bhai, if you can explain on this part.
Sorry, actually, I was pulling out the RTA of Lakshmi Vilas Bank. Sir, can you just repeat the question?
Yeah. So what is the treatment of shareholding in transferee company while calculating value per share and determination of swap ratio?
Okay, so basically they value and arrive at the swap ratio. The valuer arrives at the swap ratio based on the net worth of the company. So suppose the company which is getting merged, they will value that company and they will value this company and see how much shareholding will get swapped. With respect to the ratio being worked out, they will see the value. You see one judgment I had taken where it was the value was only 22 lakhs. So if you see the balance sheet value, it was only 22 lakhs, but they were paid some 14-15 crores. Therefore, in the next round of litigation, which I think is the parameters which the valuer fixes for valuing a company, because a paper valuation will not do now. You see, now the law has come whereby everything has to be valued by two valuers, and there are three classes. So land and building is one class, plant and machinery is one class, financial assets is one class. Now every class has to have two valuers, and the composite value of them will be taken as an average. If suppose, let's say, one person has given 10 rupees as a value, another person has given 40 rupees as the value, then the law says a third valuer has to be appointed. They cannot take the average of 40 and 10. Third valuer has to be appointed, and then after that third valuation, the near about valuations will have to be taken as an average. And I have seen this in the Cadbury's judgment. Mondelez India is the citation of the judgment, whereby there was one of the big four was the valuer, and that valuation was challenged on these particular parameters, that the swap ratio is not correct, and therefore it was revised after erstwhile company law board order thrice. Three times the valuation was revised, and then only the shareholders were satisfied. So yes, there is going to be a huge litigation on regard to the valuation.
Thank you, sir. Next question from Kamalji. What happens if an corporate debtor brings a scheme, but the corporate debtor has fraudulently passed funds to associate concern and sold off proprietaries in the last few years beyond 1 year of CIRP commencement? Can forensic audit and or criminal action can be taken against the CD for defrauding creditors?
So I think person is asking about the Wipro case, which is there, which is going on. Criminal case has been there. They have now, Ajim Premji had moved High Court with his family, and they have got some protection from High Court. Yes, sometimes such criminal law can also be set into motion, whereby it can be told to the court or it can be demonstrated that the money has been siphoned off. I'm not commenting on the Wipro case because the matter is sub judice, but yes, some type these cases are there, and I have seen 2 or 3 cases whereby the criminal action or the FIR has been lodged, whereby they are alleging that there is a siphoning of funds. Probably they might not be able to sustain it in NCLT because as per section 230 subsection 4, The limit is 5% and 10% for shareholders and creditors. But criminal law investigation can definitely be done and it can be questioned. In fact, I would say I was for minority shareholder. We objected to one of the scheme of arrangement by Alembic Pharma, whereby the private companies were getting merged with the public companies. But on the account of maintainability, our objections were rejected. So there were some issues with regard to valuation report which shareholders had questioned, but company was not divulging those valuation report. Then objections were filed before NCLT, but then NCLT rejected that since you do not hold the minimum number of shareholding to object the scheme, therefore we cannot entertain your objection. So this is a dilemma. I would say yes, it is a dilemma that if you are a minority shareholder less than this prescribed limit, your objection, though may be genuine, though may be correct in law, may not be taken because of the maintainability issue. So the best part is you exit from the company, because if you are in a public listed company only, then you will go and object. But as far as private limited companies are concerned, you will have access to their all the documents, and therefore in private limited definitely such things can be objected to.
Thank you, sir. Rahulji is asking, if a company want to retain land and transfer all other asset and liability to a resulting company, does this need to qualify the definition of undertaking for demerger?
Okay, so now this is a perfect income tax question. In fact, under income tax, if you want to take benefit, I think section 219AA is there, which says what is demerger and what are the conditions. So if you do not fulfill that condition, you will not have the tax benefit. However, as far as NCLT is concerned, they might approve the scheme, but your tax benefit is subject to Income Tax Act. So therefore, always they take an undertaking. In the schemes, wherever demerger is there, I have seen a standard clause. We will comply with all the conditions mentioned under section 219AA of Income Tax Act for demerger. So that is how you will have to comply with. So Income Tax Act is a separate law, as I already explained, and if you do not comply with the condition of income tax law, probably you will not have the benefit of tax. You might have the merger done, but you might not have the benefit.
Thank you, sir. So there are a few more requests for presentation, and we have a last question from Shweta ji. Can illiquidity discount be applied in adjusted NAV method also? Can liquidity discount be applied in adjusted NAV method also?
I think again this is a purely a valuation question. You will have to ask the valuer, because I think we both are not valuers. This is something which is very subjective, and it will have to go by the valuation standards. So I think this is a question which will be better taken by a valuer, because discounting value is something which we have to go by what the industry is giving. We cannot actually sit here and say that a pharma company's percentage or a discounting value will be same as an FMCG company. So this is a very, very subjective question.
So thank you, Nipun Bhai, and thank you, Vinit Bhai, for a wonderful deliberation. Even Vinit Bhai's session, we can say a marathon session, has to complete in limited time. So he is watching the time and clock, and accordingly he has finished in time. So would like to request all the participants to follow and connect with Nipun Bhai and Vinit Bhai over LinkedIn and all other social media. So both are very active. Even Vinit Bhai is very active. Nipun Bhai is also very active on professional network, LinkedIn and other social media. So you can connect as well. Yes, I think Nipun Bhai is showing the RTI. Yes, please.
Correct. Are you able to see? Yes.
Yes,
so this
sir,
was
yes,
an
sir.
RTI which was filed by me. So you can see the questions we were raising. This is the information which we sought. You can see we asked for all the file notings with regard to this RBI taking an action of Lakshmi Vilas Bank. They said that it is exempt. So I don't understand how it is exempt. Practically speaking, they have denied this first, second. Then point number 3, this is very important. Expression of interest was never invited. So see, if we are selling today anything in public domain, or Reserve Bank of India is selling, they are not putting a public notice. So in my view, this is incorrect. Then you can see I had asked for the copy of the scheme that they have provided. However, when I asked that whether there was any comment which was asked for this draft scheme, they said that again this is exempt. Then I also asked this question with regard to IBC, whether any Section 7 application was pending and why IBC route was not taken. Again, they say that we do not have any specific information. Last, you see NCLT or Competition Commission of India. Were these persons also taken care into when this scheme was there? Again, they say we do not have any specific information. So my point is that we filed it, we got the answers, the writ petition was also preferred. In fact, four or five high courts were there. I am also involved in the litigation. Now the matter is gone to Supreme Court. Point I am trying to make is sometime, I am not saying always, but sometimes central government also takes a decision aggressively without following the due process of law. And in this particular case, RBI has done it. It is not central government in this case. RBI has done it, and therefore I think that probably this is not a good measure in the democracy, because when we are selling even a 1 crore rupee asset, we are putting it on public auction. In this case, complete Lakshmi Vilas Bank was sold without putting it up for public auction, without actually knowing how the valuation was derived, and equity shareholders have getting zero. There is not a single penny given to the equity shareholders. So in my view, this particular process adopted by RBI is not correct. However, since the matter is sub judice, it is wrong for me to comment anything because Supreme Court is there to take care of all these legalities. But in my personal opinion, this is not correct. Virag bhai, I have
Thank you so
completed.
much. Yeah, thank you so much, Nipun bhai. So would like to request all the participants to watch RTI session also as taken by Nipun bhai along with Mahadevji Birla. So that is also very useful. That is also available on our YouTube channel, and this session also available on our YouTube channel. You can watch that if you miss any part. And also that presentation will request both the faculties and will upload on our YouTube channel in the description. So kindly you can download from that description as well. So thank you once again to all the participants for joining in the early morning on Sunday, and thank you to the faculties and President sir in absentia.
Thank you very much.
Also Praveen Soni sir, Central Council member, joining in the morning and making the webinar a grand webinar. And there are many other viewers also watch the webinar on LinkedIn and on Twitter and Facebook as well. So thank you to all your efforts. Thank you so much, Nipun bhai and Vinit bhai, for a wonderful session. Thank you all the participants for asking their question and making webinar a very interactive webinar. Generally, in a webinar, it's a very, one-way webinar or a one-way knowledge sharing. But at ConnectZ, we always try for interactive webinar. And let me tell you that we have covered almost all the question, and there is no unanswered question. So that is a very, very good thing and very rare in a webinar where hundreds of participants are there. So thank you once again. And with this, we are concluding the session. Friends, we are celebrating the CA Day on 1st July and also GST Day on 1st July. So we have a 2 session on that day. First session on 11 to 1 on new networking guidelines for CA members, ICI, and on GST session on 5th year, welcoming 5th year of GST. So would like to request all of you to join that session. Recently, in today's Man Ki Baat, PM also requested for a quality top Indian CA firm, as already informed on 1st July 2017. He is reminded again to all of us as a chartered accountants. So would like to request all the chartered accountants for tuning that session, and it will really great interaction and panel discussion on that day, and along with the presentation, how we can have a great network of chartered accountant firm. And now Institute is also coming up with the multidisciplinary firm where we can have a network with other professional, company secretary, cost accountant, advocate, engineers, and many others, where we require the service of them as well to take as an for our client. So that also will discuss as and when it is approved by the institute. So with this note, with this announcement, we are concluding today's session. Thank you all the participants. Thank you Vinit bhai, thank you Nipun bhai for the wonderful session. Thank you once.
Thank you, sir.